Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder and principal of the GTA family law firm, Feldstein Family Law Group. Both myself and the entire firm practice exclusively in the area of family law, and we have offices in Markham, Vaughan, Oakville, and Mississauga. Joining me today is one of our talented associates, Lauren Harvey. Welcome back to the show, Lauren.
Thank you, Andrew. I'm happy to be here.
Well, we're happy to have you today. So today we're talking about something that I find for some clients is a struggle when I talk to them about it, which is optics. They can be full of anger, they can be full of frustration, and they want to lash out and strike out at their former spouse, and they're not appreciating how that actually may play into the narrative that the other spouse tries to generate in the case. And to me, family law isn't just about finding a good lawyer that knows the law, because part of the practice of family law is understanding the law and understanding the family law rules. And part of it is understanding how to marshal your client through a family law proceeding to get them the best possible result. And a good result doesn't just mean a good result, it also means trying to be financially efficient and doing it as early in the process as you can in order to reduce the conflict that will exist between families. So that's why I think it's always important, especially when people have children involved in it. So, Lauren, to you, what does it mean when we say good optics in the family law context?
I think it's about really how you portray yourself, right? To the court, to the other side, to any third parties that might be involved in the matter. So, and I know Andrew, you say this all the time. The family law is about the law and it's about the facts, but it's also about remembering that judges or mediators or arbitrators are also human beings, right? They're people who can do credibility assessments. They can assess whether they believe somebody, whether they don't. So you have to look at, in addition to the law and the facts, how are you being portrayed to the court? So, like you were saying, sometimes somebody may want to lash out or act based on their emotion, but that's the benefit of having a lawyer involved is to say, you know what, we appreciate that this is frustrating. We understand what you're going through, but also we have to look about how is this going to look 2 months down the road or 2 years down the road or a year down the road, right? If we have to end up in court, we need to think ahead for all those things. And that's why it's sometimes good to have a lawyer involved because they can be that outside party who's not the same level of emotionally involved to be able to give you that outside perspective.
Well, to add to that, I look at it this way. When I went through my own divorce, I hired outside counsel to represent myself.
Mhm.
Now, I didn't believe in going to court on my own because I was very concerned about the fact I could be emotional. I could make decisions that I would not make if I was advising a client. So I wanted somebody who I respected and was also objective to say to me, Andrew, I think that you're not thinking the right way on this one because it's too close to home. Fortunately, it didn't really happen that way, but nonetheless, it's an important thing to appreciate. The
Of
other
course.
piece that you have to understand, like Lauren said, it's not just how you feel now, 2 months, 4 months, 2 years down the road. But the real problem is some people want us to be aggressive. And what they have to understand is that judges typically don't want to see naked aggression for no purpose. And I often say you can write a letter in the same letter in two different ways. One way can be saying, you do this or else.
Mhm.
And that can be taken as an aggressive letter. Another letter can be written, we require the following information in order to properly assess the merits of our client's case. In your client's case, we would kindly request that you provide this documentation no later than whatever date. In the unfortunate event that you aren't going to be producing that disclosure, we will have no choice but to take the following steps. It's the same message. It achieves the same objective, except for some clients who are full of that anger. It's not giving them that feel good of the anger satisfaction that they want of striking out against their spouse. But from a court perspective, when a judge reads those two letters, they look at one letter as increasing conflict and another letter as saying, we don't want conflict. And when you're going in front of judges, you don't want to be seen as the person who is inflaming the conflict. They typically will want to side with the person who isn't inflaming conflict. And I'll give you a perfect example. Is in the Divorce Act. It talks about the old wording is maximum contact, the new wording is slightly different, But the idea is one of the elements in assessing a parenting schedule is, can these two people co-parent effectively? Is one person the problem in co-parenting effectively? And when someone does these really foolish things, like I remember one would write a line on a check, and then in the line item said bloodsucker. You know that that check ended up in court every time. That's just plain bad optics. Or another one I loved. I don't know if you have any of these, Lauren, but I'll never forget one where the husband set up a website and he put a talking monkey to the wife's voice. So she would leave him a message, and then he would put on the website the monkey talking with her voice. Now, it may seem really funny to somebody who's watching it, but can you imagine if the other side actually got a hold of that website and presented it to a judge? The optics of that were horrible. Fortunately, in that scenario, we got the client to take it down first before anybody found it. But this is where optics are a small item, but that's an obvious one. But there's also the optics of, are you hiding things? Are you trying to work cooperatively a settlement? Are you taking scorched earth litigation? And that takes me to another topic in this area, which is disclosure.
Mhm.
And one of the things that often will happen in a family law case is, in order to get to resolution, each side needs to provide financial disclosure. Now, in your experience, Lauren, how does a lack of financial disclosure affect a party's optics in court?
So, like Andrew said, in family law, there's often obligations to provide disclosure. A failure to do that can really be fatal to somebody's case in more ways than one. Obviously, the extent of the non-disclosure can impact exactly how fatal it can be. But in my experience, at least, Andrew, hopefully you feel the same, is judges are not very empathetic to blatant breaches of providing disclosure or breaches of order to provide disclosure. So the thing about disclosure too that I always tell my clients, and sometimes, you can appreciate, sometimes there's people who have a ton of disclosure to provide, depends what their financial circumstances look at. But what I tell clients is, if we don't provide something that is legitimate and should be provided, the implication is going to be that there's something to hide, right? And if we don't provide it, a court could make an inference based on that. So it's better to be as forthcoming as possible with the disclosure. Obviously, within reason, you need to make sure the disclosure is reasonable and proportionate to the issues that are in dispute. But Andrew and I think are talking about situations where it is, in fact, reasonable and proportionate. For example, business valuations or corporate tax returns or things like that that should be fairly undisputed as being required. A failure to provide those items, it can be fatal. And judges, in my experience, don't take lightly to, I believe, I don't remember exactly the judge, Andrew, but I believe there's a line that says failure to provide disclosure is the cancer of family law or something to that effect. And I think in a lot of cases it's true because it's really something that you can't proceed with a lot of matters without. There's matters that are years into it, still looking at disclosure, right? So it can really hold up a matter. And I don't think courts are very inclined to allow that to happen in most circumstances.
Well, it's interesting you say that, because that quote of cancer of litigation, the scourge of litigation,
Yeah.
there's a lot of things in family law cases that really discourage the concept of lack of disclosure. And at some point in time, when a judge makes a final ruling in a case, and there's going to be an argument about costs and who has to pay costs, and you've been a difficult litigant, costs may be significant.
Mhm.
And like Lauren is saying, before you even get to that decision, and the court has discretion, they can find an adverse inference. I always remember one judge saying to me at a conference, if you're not going to give the disclosure, then Mr. Feldstein is going to assume. And when Mr. Feldstein assumes something, I'm going to be pretty obvious that your client isn't going to like his assumptions.
Yeah.
And a court may accept his assumptions because your client hasn't given the documentary disclosure that is solely in his or her control, that could dissuade the court from that position. So
Yeah.
it's really important to get in front of that. The
I
other risk that you have
Sorry, go ahead, Andrew.
the other risk you have with respect to disclosure is you may be in a situation where your pleadings could be struck. And that means a court could say your breach of your disclosure obligations are so flagrant that you're not even going to be able to participate in the proceeding. So I thought you were about to say something, Lauren. I apologize if I interrupted.
No, no, not at all. That was part of what I was going to say is sometimes something as what someone could seem as, overreaching disclosure requests could have a potentially fatal result, such as somebody's pleadings being struck or a catastrophic cost award or something like that. What I always say to clients to remember too is a decision that you make early on in the case. So for example, not wanting to provide an item of disclosure that is relevant could carry on with you throughout the entire matter. And later on, if you're refusing to provide something, let's say whether it's relevant or whether it's not relevant, it could come back and kind of haunt you later on taking those unreasonable positions. And I always tell clients, in court, sometimes you only have one opportunity to make a good first impression, right? Because even if you get a different judge, if there's comments that are hurtful to your position in an endorsement, right, or in a ruling, other judges will see that when this matter goes to the next step. So it's better, obviously, always to be open and honest. And disclosure, I think, probably is one of the areas that I often see where we're talking to client about optics. What are the optics of not providing this item of disclosure, right? What are the consequences down the road? So it's something that, could have really catastrophic consequences, and we need to reiterate that to clients.
Well, I'll carry it one step further. When you talk about endorsements, so our viewers can understand, every time
Mhm.
we go to court, a judge writes basically what happened in court and whether they're making any orders, and that's called an endorsement. And what judges will frequently say is the first thing they read before they hear your matter in court are the endorsements from the other judges, because that's the one neutral thing they have to look at. And if they see a history of non-production of disclosure, obstinacy, they're going to know how to that you're a difficult client, and they're going to come in right out of the gate, and they're not going to have much patience for you. You don't want to be in that position. I mean, I just remember one guy when you talk about optics. We had a court order to seize the assets of his business because he was reluctant in disclosing. So when we showed up to seize all of his assets, we caught him stuffing about $40,000 of cash in his pants. And you can imagine, to go to echo what Lauren is saying is when you have that bad optic,
Mhm.
every time I was in court on that matter, my submissions included, Your Honor, this man was caught stuffing $40,000 of cash in his pants. And there's just a certain reaction you're going to take every time that right away, this is a dishonest man. This man wasn't forthcoming in disclosure. And it takes it down a certain pathway that can be very, very difficult to overcome because of all the negative optics. It's no different than another one. The guy bought himself a new Aston Martin. This is probably at least 10 years ago. He bought a new Aston Martin for $160,000, but he had declared income of 50.
Hmm.
How many times I would say to the judge, Your Honor, he bought a new Aston Martin. I got the point. The judge said to me, Mr. Feldstein, I got your message. But the point is, it's so clear. It's so foolish. It's so in the face of $50,000, especially when back then, they didn't have something blocking out where the judge is parked. You would walk into the courthouse and you see what the judges are parking in. Not one judge is driving a car as fancy as the Aston Martin, but I can promise you they were making more than 50. So
Mhm.
you know where their minds are going.
Mhm. I
So
think that goes back to the point, Andrew, of judges are humans, right? They have these like preconceived notions, ideas, thoughts on things. And that's what I think when it comes to optics, that's always kind of the first thing that comes to mind is a judge is obviously very knowledgeable in the law, but they're also a human, right? So you need to look about how all of our behaviors day to day or in court will come across to somebody else, somebody who may not know you and may not know the person that you are, right? They only know a snippet of what's being presented in that case, right? They may not know the history of everything that happened in the relationship, right?
and and the critical point I always say to clients when it comes to optics is think of the story you're telling.
Mhm.
Does it sound truthful and believable?
Yeah.
Because when you're trying to tell the story of, I make $50,000 a year, but somehow I had a good year one year and I was able to buy an Aston Martin, it it just doesn't make any sense because if you say I have three kids and I'm married 15 years and my former spouse makes $20,000 a year and I make 50 and one good year I ran out and got an Aston Martin, nobody is believing that. And you have to know that. So I try to say to people, your financial disclosure and where they're asking questions, your answers need to have logic and make sense. And we as lawyers also need to get ahead of that because sometimes the other side, I remember one case, the other side said, my ex makes, 700,000 a year and he's only admitting to making $400,000 a year. And we live in a $3 million home and he drives a fancy Porsche that's fully paid for. And the answer to that was, yeah, the $3 million home we bought 20 years ago for $600,000. And the Porsche was bought 4 years used and is now 12 years old. It's important to make sure you get those optics out. So one side is trying to take that truth and manipulate it because in the first hand you think, wow, must be 700 to be in a $3 million home and driving in a Porsche until you hear it's bought used, it's 12 years old, and they bought the house for 20% of what they're talking about the value today. That's also optics. How you tell your story. Does it come across believable?
I think, yeah, I agree with you 100%, Andrew. I think the other part of optics too is to be honest when a decision that maybe was made, maybe it was not the best, maybe it was based on an emotional feeling, maybe it occurred right post separation, before counsel, whatever the decision may be. But I've had conversations with clients where we've said, yeah, you know what, sure, that happened. They're remorseful for it, and understand that that was not the way to deal with it moving forward. I think that goes a long way in the eyes of the court, depending on obviously the decisions and what the ramifications of that could be moving forward. But I think, again, it comes down to the officers of the court are human, right? And they appreciate that people sometimes make a mistake, but there's a value to honesty, I think, there too. So I think that's the other thing to keep in mind when you're talking about optics.
Well, what you're really talking about is that if you show remorse because you made a mistake, it demonstrates that you probably won't make the same mistake again. Whereas if you say, I did nothing wrong, and you clearly did do something wrong, well, if I don't understand I did anything wrong, then I'm probably going to
Mhm,
do it again. And the court gets that. So
mhm,
we get into a position of emotions, like you said, run high in family law.
mhm.
So one of the most frustrating times for people is the early days
Yes.
when, you know, there's a lot of literature on that a divorce is almost like mourning the loss of a loved one. And typically two people are in a different uh, they're in a different trajectory of getting over the divorce. One person, the person who has decided to end the marriage, usually has gotten over it already, whereas the other party who just learned of the breakdown of the marriage is can be very angry and they want to lash out. And that's where they're going to want to, at the beginning, they want to talk about the cheating. They want to talk about all of the dirt regarding their former spouse. And I'll never forget, I once got a pleading where it was just littered. My office we didn't do it. We inherited it from another lawyer, but it was just littered with all sorts of anger throughout it. And I said to my client, this is terrible. You may be morally feeling justified to say all these things, and I understand why you feel all these things. However, legally, this only hurts your case because they can demonstrate that you're not ready to co-parent.
Mhm.
And now we have to clean this up and we have to acknowledge, and you now not need to go see a counselor so we can say that you're seeing a counselor and you see how this doesn't help. And it goes to what you're saying is I got to take those horrible statements that I know the other side is going to want to throw at a judge every step of the way. And I have to say, no, our client has gotten over all of this anger and now appreciates the need to co-parent and that needs the ability to move
Yeah.
beyond it. And it's a really good point that you brought up because without doing that, it's the only way to get over that
Mhm.
history of the negative optics.
Yeah.
And the thing that I would say to people who are really angry about the cheating that a former spouse did, you have every right to be angry. You have every right to be hurt. But the right people to talk about it are your counselor,
Mhm.
your friends, your parents, whomever.
Not
But
the
it
court.
doesn't but it doesn't belong in the court hearing. It doesn't belong with respect to your children. These are things that will only come back to hurt you. Because I've had clients say, but the kids need to know. They actually don't.
No.
They actually shouldn't. You shouldn't be telling the kids that. Sometimes it happens. We are human. We do make mistakes. But try not to do that and understand if you do that, that will hurt you in the case. That will not help you. A judge won't be pleased that you did that. And a lot of times, uh, people will say things during the course of litigation along the lines of, well, the kids don't want to go. The kids don't want to see the other parent. I mean, how often do you hear that one, Lauren?
Probably every day. Probably heard it a few times today already. Yeah.
And what do you say to people when they say, well, the child, they're 7 years old, but they don't want to go see their mother or father?
I use the classic example, Andrew. I'm sure you've said it too. If the child, you're smiling, so I feel like you might know where I'm going. If the 7-year-old woke up and said, I don't want to go to school, would you say, okay, no problem, for not a valid reason, right? Like they're not sick, they're not anything like that. Would you say, okay, no problem, the 7-year-old decides that they don't feel like going to school? No, kids are kids, right? Obviously, at a certain age, the child's views and preferences may hold more weight, but not when we're talking about a 7-year-old, right? And what I often remind clients in this situation is one of the factors a court will look at is whether in determining the best interests of the children, so by proxy, where that child will live, how much time they'll spend with either parent, is the parent's willingness to support a relationship with the other parent, right? So parents have an obligation to do that. And that's what I try to remind them because um, I get it, and Andrew said this earlier. It's hard to go through this process, and I can emphasize with that, but we need to look at kind of how decisions we're making, how things that we're saying will be looked at if this matter were to go to court. So a strategy that I have in terms of trying to save myself from or my client from some of these optics later on is whenever I'm drafting materials and I put a fact in or a situation or an incident, I'll ask myself, how does this incident telling this actually help with a relief that I'm seeking, right? And if it doesn't, maybe it means it's not appropriate to be in the materials, right? You provide a certain amount of background, but you also want to make sure that you're not just saying something to say something, right? To paint the other side badly. Sometimes those situations are helpful in seeking the
There's
relief that
a
you're seeking.
Well, there's a big difference between trying to paint the other side badly for behavior that is clearly badly.
Right.
So when one parent hit the other parent
Right.
and you say, we had an argument on such and such date, and at that time my former spouse threw me into a wall and choked me. That's okay to say because that
Of
happened
course.
and that's relevant for
And we
decision.
consider
Relevant.
domestic violence in the Divorce Act and the Children's Law Reform Act. So exactly, I would look at that situation and say, does this help me achieve what are maybe we're asking for supervised parenting time, maybe we're asking for alternate weekends, whatever it is. Does that fact help me claim that why help support why I'm claiming the relief I'm claiming? And if it does, then absolutely it belongs there. But something that happened, something that they had one night of bad drinking 25 years ago, right? Like, does that
Well,
really help in this case? Maybe it does, but maybe it doesn't. Those are the questions that I ask
I-
myself to try to help from the optics perspective for my client.
I had one time where the other side was really angry and littered their litigation material with the fact that my client was addicted to internet porn. And they had a newborn baby. And the complaint was is after the baby was put down and went to sleep and the mother went to sleep, the father would watch porn. And it was littered about him that he had this addiction to porn that we'd watch after everybody went to sleep. And when we got to court, the judge called myself and the other lawyer into chambers, and she confronted the other lawyer and just simply said, basically, what your comment was, Lauren, how does any of this assist the pleading? How does any of this help resolve the dispute? And how is any of this relevant? Because it wasn't relevant to parenting, because what he was doing was after the baby was
Yeah,
asleep. It wasn't like you're saying he stayed at work late, or, where we get into the mistresses is a better example, is
yeah.
when someone says you had a mistress or you had a boyfriend, you're having an extramarital affair, and you were never around to parent the child. Underline that part because that's where that's
That's
relevant
the
to a
relevant part.
parenting
Yeah.
dispute.
Yeah, I agree with you. I
But
think also with our materials, like Andrew, you know this, we're limited in terms of all of our materials in terms of how much we can put in case conference briefs or motion materials. So really everything that you're putting in the materials should really be a way to get you what you want to get, right? We don't really have room for fluff in a lot of cases, right? Because we're limited by page restrictions. So that's another thing that I try to remind clients is we need to get in all of the helpful information. Um, and that's really what's important to show the court because we need to show the court why we believe that the relief that we're seeking is in the child's best interest or in accordance with the law or whatever the situation may be.
and the message we're trying to say to our viewers who may be clients or future clients of our firm, or even if you're self-rep, is don't go to court angry. Don't look at a judges to say you were right or and they were wrong. You're good, they're bad. They're not going to do that. What they're going to do is they're going to make an arbitrary decision based on the law as to what they think is right for your family. And as most judges would say, and they've said it many times, you got to be crazy to let a third party make these decisions for you. You're much better to make them yourselves by reaching an agreement.
I
And the
also,
point that we're saying is you can be locked in and get stuck with a bad deal or a bad order because you made bad choices. You didn't want to acknowledge those bad choices. You don't want to clean them up. And you're not showing an ability to co-parent, or you're not showing the ability to provide the disclosure that you need to get to the resolution.
Mhm.
All of those things will lead to results that aren't helpful. And I know I have clients who will say to me sometimes, Andrew, why are you agreeing to provide that disclosure? Why do you agree to that? And why
For the
you
order.
that? Why not fight them on it? I go, because I've been doing this 30 years. I can tell you I'm going to lose. And an order looks a lot better if it's on consent and you're being reasonable about providing it than you opposing it, paying me to oppose it, and then getting dinged to pay costs for the other side. And the judge knows from reading that decision on disclosure that your client doesn't want to provide disclosure. I'm talking about the obvious ones. Sometimes there are things that are worth opposing because
Yeah, of
it's
course.
disproportionate, it's not relevant, it's not reasonable. So you oppose it because it just doesn't stop. But I'm
Mhm.
saying when you have obvious things, don't fight those things. It's going to hurt you more than it helps. And the game of,
And it'll
well,
cost you
right.
more.
Yeah,
Yeah.
and the game of I'm going to try and run the other side out of legal fees. Well, if they get to the end, the court may interpret that as scorched earth litigation tactics, and
Mhm.
they don't look favorably on that scorched earth litigation tactics when it's done. So there's a lot that we're talking about, but optics are important. And Lauren, I would say to you,
Mhm.
how does a lawyer help a client overall with their optics in court?
Well, I think and I think we've talked about this a couple times, is really looking at it, at least this is my strategy, is looking at it and saying, is first of all, preparing them for the court appearance, right? I think it also, I often spend quite a bit of time preparing my clients before the court appearance. What can they expect? Are they going to be required to speak? And how can they let me know if they have something to say so that we're not there and they don't look optically bad physically before the court? I also prepare them, what they might hear some things from the other side that they don't like, right? And their reaction to it in court could definitely cause problems down the road. So you prepare your clients for court. That's one way. The other way I think is even way before that, when you're drafting the materials, right? Being careful about what you're putting in there and really getting back. I know I'm belaboring the point maybe, but does it actually help me in what I'm seeking? Right? Because that's something that, and it's one of the hard things that you work through with clients because a lot of them have been hurt, right? They've gone through a lot and they believe that the world should know all of these things that happen, right? And I empathize with them, but having a lawyer who is not as emotionally involved, being they're not one of the parties going through the separation or the divorce, I think can really help from an optics perspective because they can let you know, okay, this fact that you're telling me is actually helpful in our claim for example, primary parenting or whatever it may be. Whereas this fact, something that happened 15 years ago, maybe not as helpful, right? So having that kind of objective standpoint. And we've been I mean, you obviously, Andrew, far longer than I have, but we've been doing this for a while, right? We can typically tell how will a court interpret this fact that I'm saying? Will they look upon it favorably that I'm disclosing it? Will they not look upon it favorably? So that's kind of the assessment that we do in our minds. So I always tell clients, rest assured, if I took out something in the materials that they put in, there was a reason for it, right? And making sure that I explain to the client what that reason is so that they understand that it's not about not following advice, it's wanting to protect them from potentially bad optics down the road.
Well said, Lauren. I notice that we are now out of time, so we hope that our viewers have got an idea of how optics in the family law context works, how to appear more favorable in court, and how your family law lawyer can help you navigate this family law process. If you are looking for assistance as part of your separation or divorce matter, feel free to contact us. Take a look at our website, separation.ca. The next Ask Andrew show is on Tuesday, March 26th at 12 noon. If you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.